Hi, and welcome to the show. Subscribe at kevinmd.com/podcast. Today, we welcome back Dennis Hursh. He's a health law attorney. Today's Kevin MD article is Doctors Beware How Vague Contracts Put Your Job at Risk. Dennis, welcome back to the show.
Thanks. It's always good to be here, Kevin.
All right. Tell us what your latest article is about.
Well, there's a very reasonable looking clause in a lot of physician employment agreements that says basically if the employer determines that you're giving poor quality care, then the employer can terminate you. And a lot of physicians look at that and say, well, that's fair. If I'm obviously, if I'm doing bad care, then they should get rid of me. But the problem is, it usually says something like, if the employer determines. So if the employer determines that you wore a white shirt Tuesday, I think that intimidates patients. Well, I, as the administrator, have determined that, and I'm terminating you for poor quality care. So I see that tripping up people. I used to give that example as a crazy example that could never happen. But I mentioned in the article, I spoke to a female physician who was fired and told it was for being unprofessional. And the problem that she did was she wore a purple flowered lead apron. She was an interventional radiologist, and that was unprofessional in the administrator's opinion, and that was good enough. She was terminated for poor quality care.
So, in terms of these contracts, there's no metrics or objective measure that can determine what's poor quality care or not.
Exactly. If the employer determines, that's it. So in that case, the purple apron, the employer determined, and that was the end of that.
And are you seeing more and more instances of unreasonable definitions like the one that you describe in terms of defining what poor quality care is?
Well, I haven't seen a lot, but I've seen a few. I mean, I used to do this, as I said, as a crazy example. And now in the last year, I've run into two where people were actually terminated because of that kind of crazy thing. The second one was a physician who had a family member die and called in many hours before his shift was to start. And basically, he was threatened if he didn't come in, he would be terminated for poor quality care. And, again, not showing up with plenty of time. It's one thing if you just don't show up to your shift, but there was plenty of time to get a replacement. Just the administrator didn't care to go to the expense. So,
And in terms of getting terminated for quote unquote poor quality care, tell us about the detrimental effects on has on a physician's career.
well, if they do that, they should not report it to the National Practitioners Data Bank, but many times they do. I had somebody I spoke to who told me that the hospital's attorney, out of abundance of caution, reported a medical leave. He was just 90 days. He was stressed out and he took 90 days off. And the hospital council, out of an abundance of caution, reported that to the medical board as possibly impaired for his licensure. So he's going to be explaining that for the next 20 years, what
Mm.
that was. Of course, and the board actually looked at it and of course sent him a letter saying we don't think a disability is an impairment of licensure. But as I said, for the next 10 or 15 years, every time he fills out a credentialing application, he's going to be explaining that. So the biggest concern is the National Practitioner Data Bank by far.
And that vague language, is that pretty much universal in all physician contracts that you review?
I see it a lot. I won't say universal. What I want to see is good faith, reasonable determination, but I'll accept reasonable because that gives you an argument. You can come back and say, hey, that wasn't reasonable. But no, I see a lot of them that just simply say, if we determine it's poor quality care, we can terminate you immediately.
So, in terms of negotiation room, it's just a matter of inserting that type of language, good faith, reasonable. There's no way to include like specific metrics that can define poor quality care.
I do. I usually suggest that the physician and the employer jointly pick an expert. We both agree that this person is an expert, generally in your specialty, and that expert examines the physician's quality of care. And I mean, my standard is if the expert says your care is below standard, you have 60 days to bring it up to standard. So you're looked at again in 60 days. If it's still not standard, you're terminated. But the idea isn't just, some MBA determining you're giving poor quality medical care,
Mhm.
that you have somebody that knows a little something. A lot of lawyers ask for due process. Usually I don't. The reason being the employer definitely has to report to the National Practitioner Data Bank. If you have a hearing and you're found to have given poor quality care, that must go to the Practitioner Data Bank. So I usually don't ask for a hearing. I usually ask for that expert.
And are most medical institutions, are they amenable to that modification in language that you suggest?
Some are, some aren't. But if you ask for that, sometimes you can settle for a reasonable determination, which is a big jump up from just whatever we say, that's what applies.
So, assuming that a lot of physicians don't have that good faith, reasonable language in their contract and they get wrongfully terminated for subjective poor quality of care, what kind of recourse do they have?
I don't think you have much because your contract says that if I determine it's poor quality care, you were terminated. And I did, in fact, determine that. So, as the administrator, so you're terminated. So, I don't think they have a lot of recourse. I mean, if there's a report to the National Practitioner Data Bank, the damage to your reputation and everything at that point, I think would give you recourse to go after the hospital. But again, maybe in 6 years, congratulations, you won. And for all that time, you're reporting it. And even after that, you'll probably have to report it and say, it was found to be frivolous.
So, for physicians negotiating their first contract or renegotiating an old contract, that specific language is that where is that in terms of the order of importance? There's so many things important in a physician contract, but where is
Well,
that in terms of the
I
order
think
of
it's
importance?
less like, and it's one of the less likely things. I mean, it's not, to say you wore a white shirt, so you're a bad doctor, I think is kind of a stretch. It does happen. I think things like patient contact hours
Mhm.
and, evaluation of compensation, in my mind, are a lot more important. Call coverage limitations, those sort of things.
So, in terms of, we've talked about contracts many, many times on this podcast, but just go again in terms of how important it is to have an independent review of a contract before a physician signs it, just as a reminder to our audience
Yeah.
about some of
Well,
the
yeah.
problems that arise if that doesn't happen.
Well, I mean, this is one example. You get terminated because you wore a purple flowered apron. But a lot of times, too, just too much ability of the employer to make a determination. There should be a limit. Where are you going to be working? It can't be where I assign you, because with health systems taking over the globe now, they can say, hey, we bought a new hospital 80 miles out of town, and that's where you're going to be Thursdays from now on. So you want some specification on where you're working. You want patient contact hours. You want reasonable limits on call. If you're doing more call, you should be paid. There's just a whole lot of moving parts. And I think somebody that's never been bitten, I have people that I review their second contract because their first contract, they said it said this, and I never thought that that would happen, but that happened. So there's just a whole lot of moving parts in there that can come back and bite you. And that's why I think it pays to have it reviewed.
And to sum up, when it comes to these vague termination clauses, an optimal outcome from a physician would be inserting words like good faith and reasonable, and perhaps some type of third party physician to review the potential termination reason.
Yes, I think so. I mean, again, optimal would be an expert that you and the hospital or you and the employer agree on, but at a minimum, it should be reasonable.
We're talking to Dennis Hursh. He's a health law attorney. Today's Kevin MD article is Doctors Beware How Vague Contracts Put Your Job at Risk. Dennis, as always, let's end with some take home messages that you want to leave with the Kevin MD audience.
Yeah, I think you should always look at an employment agreement. To me, one of the most important things are the termination provisions, and just make sure they're reasonable. That's the biggest thing. Everything should be reasonable, but termination clause in particular should be reasonable.
Dennis, as always, thank you so much for sharing your perspective and insight. Thanks for coming back on the show.
Sure, it was my pleasure.